So this is absolutely true. When you die intestate without a will, your estate is more complicated, more things need to be done, and it can be way more stressful for your estate solicitor and your family trying to sort out your estate. So when you die intestate, the first thing we need to do is work out who's going to be your administrator. When you die and you make a will, you set out who you want to be your executor. So the choice is clear, it's clear who the executor is. But when you die intestate, it's not always clear who should be in control of your estate, and we can often take some time to work that out, or there can be argument between certain family members or your spouse and your children about who will be in control of your estate. And in the worst possible case, we might end up in the Supreme Court just arguing over who's in control, who's going to be the administrator. Once we've worked out who the administrator is going to be, we then need to do extensive searches for a will. Even if we know that there's not a will, we've got to write to banks, the Law Society, any of your accountants. We've got to search your personal affairs, search your house, search through your documents. We've got to properly do that. It's not just a tick and flick exercise. Your administrator really needs to show that they have tried to look for a will and we're confident that there isn't one. Then once we've done that, we need to identify all of the entitled people to your estate. Even if your estate's really small, we've got to find all of those entitled people and then serve them with notice. So if you've got an estranged family or a complex family where you don't know where people are, often I need to engage personal investigators to go and serve people. And that all costs money and time. I've got an estate at the moment. We're about 2 years in. We still haven't served everyone properly. The Supreme Court won't progress the matter until we find these people and serve them. So I now have to get a personal investigator to do a skip trace. It's just a whole mess, and it's costing thousands of dollars more than it would have if there was a will. Once we've served everyone with notice, those eligible people can then they can then make their own application if they don't agree with the person being the administrator. So essentially you're serving people with notice and giving them notice that you're about to do something, and that they are then more likely to contest your will. When you make a will, we don't have to serve anyone who's not in the will. So really when you die without a will, in my view, there's more likelihood that you're going to have a contest on your estate. Please just make the will. They're so simple to make. They don't have to cost an arm and a leg. Please just get in and make your will, because when you die intestate without a will, there's so much more that has to be done. And estates are already delayed and slow enough when you have a will. Don't make it worse for your family.